So, Dr. Brenda Bauer-Smith, Department of Health Court Evaluation Branch, and Cynthia Pangan, Supervisor at the Adult Client Services, will be discussing the examination process of defendants under Chapter 704. Thank you.
Good morning. For those who don't know me, my name is Cindy Pangan, and I am the PSI Supervisor here in Kona. And I'm going to be basically just briefly explaining our process and what we do once we receive the order. So as we receive the order, either via computer or fax, that same day, we assign the case and the file is opened. So all the pertinent information is entered into our database. And then I assign it that same day to a PO that will be conducting the interview. Once the PO is given the file, the PO establishes where the defendant is. So if the PO realizes that the defendant's out, they contact the defendant via, telephone, set up a time to do the interview either in the office or on phone, whatever is going to be easier for the defendant. If they're at HCCC, we are at their kind of beck and call. So they will start calling generally the next morning to try and get the defendant on the phone. We do run into issues with this. Currently, they've been in construction and they're constantly put on lockdown, but we will stay persistent until we can get the defendant on the phone to conduct the interview. If the defendant is in with the Department of Health and at Hawaii State Hospital, at that time, then we have to get in touch with a social worker and set up the interview that way and get some assistance to complete that process. Once the interview is set up, the interview itself lasts for about 30 to 45 minutes, depending on how much information is provided. We use a 4-page document that pretty much is all familial history, basic back history, education, employment, but primarily medical and mental health history. And it is anything in their lifetime that they can report. And the reason that's so important is because this is how we establish what consents and records that we need to compile for the examiners. So it's really important that we sit with them for a while. Some of the 704 participants are not very good historians, as some of us know. So we sometimes have to remind them, like, have you been to Hilo Medical Center or have you been to Kona Hospital, to make sure that we get all the information that we need. Once they've completed that process, now we have to go to consents. So it sounds easy, but a lot of places will not take the state of Hawaii judiciary consent. They have their own consents. Some of the larger agencies here in Hawaii, as well as a lot on the mainland. So sometimes the POs will need to do some investigation to get those consents. But as soon as they can pull all those consents, we will send those out for the signature of the defendant. Again, that might be email, that might be the defendant coming into the office, that might be HCCC for Kona right now. We send our consents over to our Hilo office, and that branch goes once a week to have those consents signed and returned to us. Due to staffing, it's only once a week, unfortunately. And then if it, again, is state hospital, we have to get in touch with the social worker to get those consents signed and returned. Upon getting those returned, they immediately send out the request. Professional courtesy, we allow a 2-week turnaround for records. And that being said, we try to stick to that date. However, the larger agencies and many places on the mainland can take 4 to 6 weeks. And they will tell me up front, it's 20 to 30 days for us to turn it around. So we do what we can. The POs after the 2 weeks will start kind of nudging them along, make calls, resend faxes, whatever we need to do to request those records. But sometimes we do have to wait and just keep making calls until they show up. And every agency is different. Some are really great and expedite it via email. Others, they send them in the mail and we have to wait. So And that same thought, we will not wait forever. So I don't want you to think it's like some endless cycle that we try to wait. If we feel it's pertinent, if they're mental health records, we really want to wait as long as we can to give the examiners all the information they need. However, if it's like, John Smith had his toenail removed at age 9, we're not going to wait for that. So we try to move it along as best we can with the most amount of information we can provide for the examiners. Also, just to backtrack a little, because I did kind of skip over this, but if they're in court and they do not have contact information, we please ask if there's any way to send them down to the office with an order. If we can, and the person has no way of getting contacted, we will try to interview them that day, or at least set up a time to do it, to try and get it done before the person leaves the building. If they leave the building, we'll get in touch with ISC and try to find them, but if they're gone, they're gone. And we also ask that you provide the order, only because, again, sometimes they come down and they don't know why they're there. And there's no minutes and there's no order and we don't know why they're there. But if they do not have contact information, if you'll just send them down to our office, we will do our best to get the interview done right then and there. So once we get the records, and we've nudged everybody and we get the records, we compile those immediately. As soon as they have them all, we put them together. They're encrypted and I send them directly out to the examiners. They go out, there's no slow time now, they're emailed to them right away. So the email goes out, the doctors have access and they can get their reports done. If at any time there's something slowing something up, a status will be done for the court to let them know. We try to provide that about a week ahead of time. If we think we're going to need a continuance, if we know the examiner will not be able to finish the report in time, we will ask for more time for everybody. The one thing that I also wanted to mention was my counterpart in Hilo asked me to mention that Hilo is a little bit different. And they do currently have some staffing issues, so they are a little bit slower than Kona, but they also are doing what they can to expedite the reports going out as much as they can and getting those records out. And that's really it. I mean, we do our best to try and get as much information from both the defendant and gather as many records as we can to give the examiners the best chance of getting a very well put together report for the court. So, and then just so everybody knows, we do keep the records in our possession. So we always have the records should we need them going forward. Does anybody have any questions? Yep, way in the back. The question was, can the records be made available to the attorney? We cannot provide you a copy, but if you would like to come to the office and review those records, you're more than welcome to review them in the office. We just cannot provide you with a copy without a court order for those records.
When you send out packet to the data, you index what's in the packet, like this hospital.
Yes. So the question was, how do we set up when we send the records to the examiner, what that looks like? And basically, when we send it, we put it together. So there's the case number. We do a worksheet. So it tells the examiner what we have discussed with the defendant. The orders in there, the police reports in there, and then any records that are pertinent to the case, it's labeled very clearly. So it'll say Kona Community Hospital, the records will follow. Hawaii State Hospital records will follow. So they know what they're looking at. Mm-hmm. So the question was, when we do the interview, the form that we use, does the defendant fill that out or do we? It's done by the PO. So it's basically, we want to make sure we're asking all the defendants the same questions. So we use that as a basic format. The PO will make notes on that, and then we type up a nice copy to put into those records that go out to the examiner. Mhm. Over here?
Yes, could you talk a little bit, in the past, there's been some concerns about some doctors having access to some records, like independently, like the hospital records, when other doctors may not have had access to those records. Can you talk a little bit about that process?
Yeah, so as far as the records, the access to the records is we're the keeper of the records. If you want to see the records, then you can come in and see them. As far as the examiners all get the same records. If we get records late, it goes out to all the examiners. So no examiner should have records that another examiner does not have. We make sure they all have the same information to view to judge their decision-making on. Does that answer the question?
Yeah, I think it does. I think that just anecdotally, I've dealt with some cases where examiners have expressed that they actually went to Hawaii State Hospital and viewed records on site that may not have been part of the records that were sent out by your unit.
Right.
And I don't know if that is still something that you know is occurring, or if you have any information on that particular issue.
That I can tell you. So any of the examiners on Oahu will usually, for state hospital, will go over and view because they would prefer that. The problem with what we get sometimes with records, the record keepers go up for state hospital, for example. If somebody is at state hospital, she has to get the current folder file from the social worker, add it to the old stuff and send it to us. But there may be a lapse in time, I'm thinking. So the records girl could send us stuff. The file goes back to the unit and maybe a week or two goes by and now there's newer records. So it may be something where there's a little bit of a lapse of time as far as that goes, but it shouldn't be a huge amount of difference. That's why like state hospitals sometimes take us longer if they're there because she has to get that active record from the social worker to send to us. So I'm thinking that that's the only thing I can think of, that there might be a lapse of when the records were actually pulled for us.
We're gonna follow up with Brenda's question. Hospital records, hospital. If the person was on a fitness screen and now it's about to be fit, and there's a second set of examinations for it, on a fitness issue. So does the probation office now get the records for their records that can turn over? Or you're not even in the game of that?
Anytime, so the question was, will we get, if the case goes back because it was fitness only, to get new records of the person's at state hospital? So like if there's any secondary type of 704 that we're asked to do, we get updated records. So whether it's a re-exam or whatever, we go back and we'll ask for the records from the last period to the new period to fill in that gap for the examiners. Mm-hmm. Yes.
I have a question. You mentioned that included in the packet are copies of like the police reports. Can you just explain about how that process is to get that information from the state and what type of reports are included in that?
Yes. So when we do the 704s or PSIs, we request from the prosecutor's office a copy of the police reports. And whatever has been given to us for discovery purposes, that's what we submit, so that the examiners can look at what happened in the case. So it's just our protocol. We get in touch with them, they send it over, we attach it.
And then one more quick follow-up. Do you ever get like educational records if someone perhaps was on like a 504 or have like disabilities and things like that, or kind of accommodations? Do you get educational records as well?
Yeah, so she was asking about educational records. Yes, and that's a good point. So if somebody has mentioned, we will ask them about educational background. And if special ed or 504 plans or any of that type of information is included and they acknowledge that they have had those those services, we do ask for educational records. Because obviously it's important. Sometimes they're difficult to get, but particularly if they've been in special ed, we want to see what they were in special ed for. And so, yeah, we will ask for those records. Social Security as well, if they're on disability, we try to get disability records from Social Security as well. Yes, back there.
Thank you. What happens when you do not obtain consent? Or you're faced with an individual that appears to not be competent to give consent or withholding?
So she was asking what happens when we don't have consent. So if they will not sign consent, we move forward without them, without the information. And unfortunately, that's going to be a loss for the examiner. But if they do not give us consent for that information, then we cannot gather information for them. So it would just be a file of police report, order, CGIS if we have one, but there would be no records available to the examiners. And we try to explain that sometimes they're just confused, and we try to explain to them that, you know, it's in their best interest, but they have every right not to sign. So if they don't want that information released, there's nothing we can do. Leslie.
So for a subsequent exam after the initial fitness exam, like for appeal responsibility, for example, are there different types of records that get collected and are sent to the examiners?
No, we collect whatever records they have and we forward everything. And we don't personally, in as opposed to like a PSI, we do not review these records at all. We are the collector. We also do not discuss the case with the defendant. We are only there to collect information, and we explain that to them. And so when the information comes in, we don't review it. We just put it in a file and leave that to the specialty people to review and make their decisions. Back there?
Keeping the records there, does that mean that the next time you see the individual, that shorten that processing time?
The question was on processing time for the people that frequent 704s. It can, it definitely helps because any time they come, we just keep compiling those records and I'm keeping a nice database for them. So all we have to do, let's say they had one 6 months ago, all we have to collect is the last 6 months. It makes it much easier. And then we just add those to the file and then we can send it on out. Yeah. Anybody else? Thank you. And we want to thank everybody because we know it's a hard process, but everybody is very helpful when we have the 704s. So we want to thank everybody for their help and participation as well. Yes. Dr. Bauer-Smith. Thank you.
Just press this one.
Yep.
Okay. Okay, good morning, everybody. Thank you for having me. I wanted to just start with a little bit of background of what the Court Evaluation Branch is. We are located on Oahu, but we serve each of the islands across the state. So I very much appreciate having the opportunity to come and learn from you guys today. So the Court Evaluation Branch, not Courts and Corrections, although that name is fine too, but we haven't been that in a while. We are one of several branches under the Department of Health. In addition to our branch, there are the community mental health centers where a lot of the defendants who then are called consumers get treatment. And then of course, the Hawaii State Hospital. As I mentioned, our branch is responsible for completing the evaluations of fitness or competency, penal responsibility, also known as capacity, and dangerousness under HRS Chapter 704. And we complete the evaluations in all the counties statewide for the district, circuit, and family courts. And family courts also includes juvenile assessments, I know you're going to speak later on about that a little bit. So right now, everyone always hears about our shortage. We are very short-staffed. Right now, we only have 4 full-time and 2 part-time examiners, and then myself, also called state designates, who do these evaluations. So under Hawaii's 3-panel system, felony offenses are assigned to the state designate from within our branch, and then to 2 private doctors who are chosen by court or council from the list of certified private doctors. We kind of hear anecdotally how those 2 private doctors are chosen differently across the different counties. Some we've heard they're rotated, others we hear defense gets a choice and prosecution gets to choose one. So I guess it just depends on the county. Right now, there are 15 doctors on the private list, 10 of whom are willing to conduct exams out of this circuit. And despite there only being literally a handful of us, we have over 115 years of cumulative experience. And here's us, our small group, just to kind of put a face to a name. Here's our clerical staff as well as a combination of all of the examiners. Okay, so just to continue, the 704 exams can be completed in the community, in jails and prisons, and at the hospital. And I'll speak a little bit more about it later, but in the community, that doesn't mean at a McDonald's or a Subway, although it happens. So, some of the defendants are homeless, so we might have to interview them via Zoom while they're in their car or the side of the road. And there's ethical concerns as well as safety concerns and the integrity of the report that can come into play. But sometimes, you got to do what you got to do. And ultimately, if we think we can give an opinion, we'll go ahead with it. On average, our branch receives 145 new orders for evaluation each month. So that's inclusive of conditional release, fitness reeval, PR, all of that. Comes out to roughly $1,750 a year. So specific to this Hawaii Island, we get about 26 a month, which is down. I would say, I should have looked, but about a year or 2 ago, you guys were about 50% of our state's total, and it has gone down quite a bit. And about 4 of those each month are Act 26 or 87. 87 is probably the better one, but a lot of people still call it 26. So about 4 of those a month. Okay, so what do we do once we've received the order in our branch? So the procedures that we take after we get the order, whether it's a 1 or a 3 panel, all the orders directed to the Adult Mental Health Division should be sent to us via the email address. And yes, some of you might be shocked because we have drilled in one fax number for years and years and years. It still works, but you folks are actually going to be the first circuit to roll out the modernization. So stay tuned. So once we get it via the email or the one fax, which actually does turn it into an email, for us, our clerical staff will file it or make receipt of it, log it, and literally put it into a box for assignment. I'll review the orders and assign them depending on the history of the case and caseloads. So for example, if Dr. Donovan has had a case 4 times already, he's most likely going to get it back. It's for efficiency and continuity of the case. Is that a question? Oh, okay. So the question is that the identification of the percentage of orders that we receive from Big Island going down. What's the cause? I don't know. Less is better for us, but I'm not sure exactly. Again, there might be some anecdotal reasons why that's gone down, but our branch hasn't been able to pinpoint a reason. Well, okay, I guess I'm throwing out there, maybe as far as it seems like sometimes since Act 87 came into effect, some counties just won't panel somebody, or they might panel them more depending on what their reasoning is. If they know that if it's a nonviolent petty misdemeanor, and they're able to probably just get it dismissed. But no, I guess overall, no, we can't identify specific cause within our branch. Okay, so within 1 week of receipt of the order at our branch, the examiner will receive the order and a tracking sheet. That's internal to us, but we use it to collect data, anything from demographics to the diagnosis that we end up giving the defendant to our opinion. So we're not able yet to track longitudinally what the judge ends up ruling, but we want to look at things like if the national average for return on initial exam, about 60% are opined fit. So we want to look at, are we kind of in line with that, or are we really outside of the box and then we need to do some training? On average, a full-time state designate carries 52 active cases in their queue, meaning they could be working on it at any point, just got it or almost finished the report, but it's a lot. At any one point in time, our branch averages 254 defendants that are active. So that just makes sense. It might sound like a lot, but of course, every day, all the time, we're receiving orders. So there's always going to be a load of cases that we're actively working on. But just to compare, some states require a full-time examiner to only complete 10 exams a month. We have a colleague who left here and went to Georgia, and that's their quota. Ours, what I require of the defendant examiners is 15 plus. Most do about 18. So again, it's a lot on their caseloads. How do we prioritize cases? Mostly, of course, if those who've been waiting the longest, and then those who are incarcerated or hospitalized, especially for less serious charges. Okay, so next, doctors are informed. So now we've got the order. What do? We kind of wait on it until we get records. For here, the Hilo or Kona Adult Client Services branch lets us know when records are available for review. It's usually about 4 to 6 weeks that we notice we get that receipt after we've gotten the order. So as Cindy was talking about, for them, they might go in 2 weeks, but the consents might take a while, or the agencies might take a while to respond to those consents, which pushes back when the records become available. Your circuit is one of the best ones to work with for Adult Client Services branch. Some we don't even get notified that the records are ready. So it's most are not itemized out and organized like you guys do. Mostly it's just a big, huge file and we have to work our way through it. So it's very much appreciated. So yes, it's sent to us. Usually we can go to the office physically across the state. We can go into the offices statewide, ACSBs, to see them, or they're sent to us via secure password protected process. So then we review the records and then we make the appointment to interview the defendant. Sounds easy, like, oh, it's a pretty little, bow put on the records, and then all we have to do is go see the defendant. It's not, because then we have to take into consideration limited visiting hours at each of the locations. OCCC, for example, you can go in the morning and then they kick you out, and then you can come back at 11 and then they kick you out again. Sometimes there's no telehealth option or poor connection. So especially in the more rural areas, and if we're not doing it at a secure location, like at a Adult Client Services office, a PD's office, the connection can be disrupted and it can affect the interview. Of course, there can be delays because the defendant can't be located. So we might be ready to interview the defendant, but there's no contact information. And then finally, the in-person versus, interviewing them via Zoom. So just some things to consider. Now, telehealth, everybody knows since COVID, it's been proven to be a reliable and valid way of doing these type of interviews. But of course, if we're in the middle of an interview and we need to think we need to see them in person, we will do so. But there's a lot of things that we have to consider clinically, even when doing these via Zoom, even down to things like safety concerns. If they're on their iPhone in a car and we're doing an interview and they say that they're suicidal, for example, we're still clinicians and we need to then go through a process of what do we do now? And so it can really complicate it if they're not at a community mental health center or, maybe a public defender's office for us to be able to feel secure. Also, we have to be able to verify who they are. So we could have Joe Blow come to the interview and say they're Joe Smith. How do we really know? We also don't want somebody to we want them to feel safe in their interview. We don't want them to be coached off screen. We had one of the examiners face a situation where it was a domestic violence case and the person that the person was in the room and was they felt intimidating the person who they were trying to interview. So those things can happen and we like to avoid that. The interviews themselves take about 60 minutes, but it ranges a lot. Sometimes 3 minutes in, you already know your answer. Other times, you can be flying away and you're thinking, this is so easy, it's so clear. And then around the 30-minute mark, they'll say something like, I work for the CIA or something like that. And then you think, oh my gosh, now this just extended my interview. And now I have to ask every question 3 different ways to really figure out what is going on for the defendant. After we interview them, we will write up our report based on the records, the interview, assessment results. So if we do any formal assessment, complete any assessment tools, and then any other collateral information. So let's say that we reach out to speak to the defendant's treatment team. We will include that, and that should be included in the report as part of our database. So I know there was a question earlier about, do all the examiners get all the same information? From adult client services, yes, but some examiners will go out and talk to witnesses. They might, honestly, the file from the state hospital is much more extensive in person than what is usually sent for ACS records. I'll just leave it at that. So that should all be included though in our database so that the fact finder and counsel knows what we're basing our opinion on. Okay, so then we finish up our report. We give it to our clerical staff. They file it with the court. We also have to consider the time devoted for subpoenas. About 10% of our cases, subpoenas. A question came up, why don't we consult or reach out more to defense counsel or whoever asked for the panel to better understand why the panel was asked for? Realistically, a lot of it has to do with time constraints. So you might have a privately retained expert witness who is for one side or the other, which is different than what the 3 panel does or the state designate. Who the private side, might have more time. So time constraints, poor response rate. So kind of the once bitten, twice shy, where we have maybe tried to reach out, but you guys are busy too. So we might not get a response in time for court. Another reason is lack of unique or individualized data shared. So sometimes the response can be, well, because I'm asked for the panel because the defendant has a history of mental illness. Or I asked for the panel because they can't communicate well with me. That's interesting, but it doesn't really add much. And so just for efficiency, a lot of times we don't do it. And finally, we don't want to have the perception that it can be construed as favoring one side. Because again, we're not retained by one or the other. We're just, court appointed. So moving along, how long does it take? about 60 to 90 days from the time we receive an order to when it's filed with the court. So most of you guys have all seen, I don't know the percentage, but I know it's high. A lot of the cases will ask for probably a 4-week continuance on a lot of them. And we estimate it takes roughly 8 hours for an examiner to complete an individual assessment, inclusive of record review, interview, report write-up. But again, that can vary. If I'm doing a re-exam on somebody who still looks really unfit, I don't have to re-review a ton of records. The interview is fast, the write-up is going to be fast, which is much different than a more complicated case, which then can lead to having to read journal articles or case law or going back to review the records again because we're not sure what to do. But on average, 8 hours. Okay, what are some of the considerations when we conduct an evaluation? So we're considering not obviously in the same vein or light as legal counsel, but we should be aware of some of the legal precedent that drives the types of questions we're asking. Psychological best practices as well as ethics need to be considered. So I just threw out some of the ones when assessing competency, some of the precedents that we should be considering. Let's say Dusky, Jackson versus Indiana, as it relates to reasonable time to being fit. And then locally, State versus Suarez, and I'm probably pronouncing that wrong, and Tierney. And then some of the assessment tools used to help inform our opinion if we do more, I guess, structured interviews. So it's the revised competency assessment instruments, the FIT, the evaluation of competency to stand trial. A lot of these are just structured interviews, so they're not necessarily scored like an IQ test would be scored, but they help ground the types of questions that we're asking. Okay, so what are we thinking about when we assess for capacity or penal responsibility? Just for history, you know, McNaughton is history and the cognitive prong. But what we're looking at is the model code for Kauai. And so we're trying to answer the question if a person is not responsible, if they lack substantial capacity to either appreciate the criminality of their conduct or conform their conduct to the requirements of the law. At a very basic way, that's what we're trying to look at. And then, of course, I just listed some of the cases that relate to substance use at time of offense as things that state designates and the private doctor should be at least aware of as reference. Because we all know how much crystal meth is a problem, and that affects a lot of our cases. And then the third thing, what are some of the things we look at when we're considering dangerousness? So the HCR 20 is something that you guys might see quite a bit as listed as a tool, and kind of subsumed also in that tool are questions related to, does the defendant have recent violent behavior? What is their insight? Substance use history, active symptoms, and a big thing is about placement. So somebody can be still actively psychotic. Somebody can have a very dangerous history. But if there's mitigating circumstances, housing and support that's available, then we will give the opinion that they can be put out into the community. It's just, as we all know, realistically, either one, that doesn't exist, or two, the link can be hard. So you might have somebody who the judge might think, oh, they could be released on conditions today from court. But if there's nobody in court to kind of help facilitate that and make that link with AMHD, then the default might be to send them to the hospital. Of course, we got to think about malingering. And then I just wanted to throw in there the ethics of it. So there are specialty forensic guidelines for psychology, specialty forensic psychology guidelines, and whatever I just said. So really one of the big differences is that we're not, even a regular psychologist, I don't want to say regular, a clinical psychologist shouldn't be an advocate for their patient. You might want to empower your patient, but we don't do that. What we're looking at is just being very unbiased and we don't have confidentiality with them in the traditional sense. So we must tell them that as just some of the differences of doing these types of assessments versus regular therapy. Okay, and then some of the challenges facing our branch. See if that brings me. So I mentioned already a little bit the staffing. We're over 60% understaffed because one, I don't even want to know the real percentage. I just know it's over 60, and the math was too hard for me to figure out. So we're over 60% understaffed. Statewide, already this year, we've written over 200 continuances due to workload backlog, meaning everything else is ready. Records are ready, the defendant's located, but we literally cannot do it because we've got a bunch of other cases ahead of that person. We have had 123 continuances statewide this year due to lack of records or delay of records. So that can mean maybe partial records came through, but not enough. Or that could mean, hey, we're ready to go see the defendant, but yeah, the records just haven't become available. And I'll just throw another one out there. 59 continuances already this year for no contact information or inability to locate the defendant. Another challenge that we face sometimes is the poor documentation and thus limited information upon which to base our opinion. So not just for example, we might get somebody who, let's say they've been at the state hospital and we assess them and their treatment team might say, oh, they're malingering, but there's nothing in the records that's supporting that. Or if you ask maybe one of the treatment team, they might just say, well, they just are. So that can sometimes delay and make it more difficult for us to have something solid to base our opinion. And then specific to this island, some of the challenges that we face can be securing an interpreter. There's sometimes been kind of a volley back and forth between it should be us, it should be defense counsel, it should be the court. So that's something that every so often can delay an evaluation from being done timely. The big one, having a secure location with good internet willing to host our Zoom interviews. I know, again, Adult Client Services was very helpful. I mean, that's not even in there that they need to help us with, but they've always been very gracious in saying they will help. But the connection can be poor or staffing with them might be low. So that makes it difficult to do that. And then especially with HCCC, both when we go in person and if we do an evaluation via Zoom, it can be, sometimes it's a broom closet or we're in a kitchen and people can walk by the interview. We're used to that. I mean, we all know that we have to work within not ideal circumstances. And obviously, if it's going to render an invalid report, then we won't go forward with the situation. But it can be distracting and it's not just HCCC that has that problem. I mean, I've gone to the state hospital before and they might put me out in the big room with the TV on and 6 other people kind of milling around and I'm supposed to conduct an interview. So those are just some of the challenges. And now, any questions? Okay, good, none. Yeah.
Add something. I went to the national conference, which was like last month, and you talked about your challenges, the time frame that it takes you to conduct these exams. But we're actually doing a pretty darn good job because some of the states that reported back at the conference that I went to reported 2 years for a fitness evaluation. And they are now, that particular state was New Mexico, they're now at like 144 to 205 days. And they consider themselves a success story, which they are, down to 2 years. Another county reported that people would languish in jail, mind you, this is not because they don't have contact information. They would languish for 3 years pending fitness examination. And so, Dr. Bauer-Smith, when you say, 60 to 90 days and maybe longer, and we've filed 124 continuance requests, you're doing a really good job. So I just wanted to put that out there.
Well, thank you. I like that question. Thank you.
I guess,
Yes.
so for the state designates, is there some kind of standardized training or is there some uniform set of standards that the state designates are required to comply with as part of the process of being a state designate?
I guess yes and no. I mean, it's a state system. So really when employment takes place, they go through the state system of getting hired. But when I'm doing the interviews, there's a big screening process. So I guess if you want to call that kind of the formal process of kind of weeding out people who might not have the foundational skills to begin with, they won't get the job to start. After somebody comes on as a state designate, they're provided with CEs, typically, kind of like this, but usually online with PR, just a bunch of CEs that we want them to take while they're shadowing current examiners. And none of these are formalized because I don't like PNPs. It's just, that's how I've been doing it. But I would say their first 5 reports are supposed to be peer reviewed before they can be kind of a little bit more, have more independence. So no, we don't have a formal certification process for the state designates. Oh, I'm sorry, I didn't repeat the question. If there's a formal process for state designates to come on board. Same with the private doctors. There is a formal PNP for them. So in order to be added to the list, we must go through, or they must meet certain minimum requirements before we will add them to the list. But then ultimately, it's you folks deciding if you want to use them or if you think that their credentials are sufficient.
Thank you.
Sure.
I have one more.
Okay, sure.
So when talking about fitness to proceed, is looking at the type of charge and the length of time an individual might have to sit through like jury selection and the number of days of trial or weeks of trial, and participating with their counsel and discussing their options and reviewing evidence and deciding to testify. Are those things that you guys consider as part of that examination process as well?
Sure. So the question is, are we not just considering things like rational or factual understanding? Do they know the judge, the PD, the prosecutor? But are we also considering the complexity of the case? So can they just cop a plea and then be done? It's a misdemeanor case versus if it's, a felony A where they might have to go through a jury selection process, and then, be able to help defense counsel with questions. Yes, we should be considering that. And I think we get feedback from different courts differently. Some are of the opinion it should be the same. You're either fit or you're not fit. Others over the years, we used to write more reports where we would say marginally fit. And that was just like, people were just horrified by that. And I think, well, if you read, like, if you're not just reading the bolded parts of our report, you can see why that, maybe the person just needs some scaffolding. Maybe they're a little bit lower IQ. So if you got to work slower with them, or you got to be more concrete with them, or if they have 3 different charges in 2 different courts, I can barely keep track of that. So we should be considering the complexity of what they're going through in order for them to be considered fit or not.
Thank you.
Sure. Anything else? Way back. Sure. So the question is, how are evaluators kind of trained, or how do we think about how they can assist their counsel? I think I don't want to answer for everybody, but I think that's also, an unacceptable answer, because there should be some type of a baseline or minimum expectation. I can't say that there's a specific tool that we're gonna, like an itemized list of what we might be looking at. But what we should be looking at are basic things that we can glean from our experience with the defendant ourselves, even in the interview. So if I'm able to have a discussion with them for an hour and I'm going all over the place, sometimes on purpose, to see, can they cognitively shift and track? I'm talking about this, but now I'm going to talk about that. If the defendants are able to, from the examiner's perspective, be able to track that during the interview, they're able to talk about why they might want to plea a certain way, not just say, guilty means this, not guilty means this, but if they're able to have a discussion, then those are some of the things that we would look at and consider when we're thinking about that prong of whether they can assist their counsel. Also included the relationship. Sometimes somebody might say they don't like their defense counsel, which that doesn't make you unfit unless it rises to the level of some kind of delusion. Sure, right here.
Thank you. Is there a standard or expectation or policy regarding who attends the interview? And I know it's very different about people in the background and settings that you can see, but I've had at least two specific cases in which the defendants were charged with sexual assault and their mother was in the room during the examination, and it led to credible allegations of malingering because of talking in front of their mother about a sexual offense. And it did not occur to the examiner to either document that or to otherwise ask for that room. So is there some kind of standard or expectation regarding stuff like that?
I would, so the question is there an expectation or standard that the examiner needs to consider when allowing other people into the interview? Apart from, I guess, the statute that says that another psychologist, somebody can ask for another psychologist to be present in the room. Apart from that being, I guess, not itemized, but memorialized somewhere, I don't know if is it somewhere documented. I know standard practices across the board is no, that usually it's just the defendant who you're interviewing, for a lot of reasons, kind of what you explained. And obviously, unless there's an interpreter or something in the room, but we want to be able to get an accurate understanding of how the defendant is presenting, without, the coaching or of maybe a parent or a loved one. We don't want them to feel stifled with what they're saying. So usually, at least with the state designates, when we're asked if somebody else can sit in the room, we'll tell that other person no. We'll explain to the defendant and the other person, no, you're not allowed to sit in the room. We'll conduct the interview. Then we'll go back and ask that person if they want to come in and talk as a group or just talk separately for some collateral information. Sure, back here.
Process wise, the evaluating branch did file one investigation, then they send it back out.
Oh, sure. So the question is, does the court evaluation branch get all the data from adult client services branch and the records and then send it out? No. So we're all treated very independently. The adult client services branches will send the information to court eval branch and then to each examiner separately.
Thank you.
Sure. Oh, right here.
One more question, sorry. So we've had some like fitness examinations where in the report, sometimes on like F-87s where the defendant is unredirectable and somehow they're still found fit to proceed. Mm-hmm. So the examiner will say, we tried multiple times to redirect them. They weren't really redirectable, but I think they're probably going to be fine. So they're fit. So that comes up sometimes, which can be frustrating, or they have, they understand their plea options. They know who the judge is. They know who the parties are, but they have persistent, auditory or visual delusions. They still think they're part of the CAA and a bunch of other stuff, but yet they're still found fit. So how do you guys deal with those types of things in determining fitness?
Good question. So yeah, the question is, how is it that sometimes from a defendant can still be a little I guess, not speaking out in court, or they might still be a little inappropriate or have difficulty to be redirected, yet an examiner might still give the opinion that they're fit. That would be kind of hard to answer too, because it'd be specific to the case. I should know it because I'm talking about what we should know, but I think someone else is going to cover it as some kind of precedent where, later in this training, where even if a defendant is, talking out in court, and even if they still are psychotic, that doesn't automatically mean that they're not going to be fit or that they can't assist their counsel. So I think that, maybe the examiner was wrong. Maybe when the examiner interviewed them, they were a little better in that controlled environment versus in the courtroom. But if a defendant is redirectable, then depending on how hard it is, we might still say that they're fit if they're able to do everything else. It is possible, but I can understand. So that's helpful feedback to know that from that perspective, it still makes it difficulty to work with the defendant if they're having those behaviors. Okay, anything else? All right, thank you guys.